Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Today's topic is going to be legal ethics. So we're going to be dealing with how attorneys act and interact with the Attorney Registration and Disciplinary Commission. Co-host Jesse Barrientes. Jesse, how are you, sir?
I'm doing well, Dave. How about yourself?
Oh, very good. Good to see you.
You too.
This is a topic we've never done before, and I think it's an important one, but I do want to caution the viewers as we're going to be going through a couple cases where some attorneys have made some missteps, kind of gone sideways, but it's very rare and very uncommon. Just for example, Jesse, there's 65,000 registered licensed attorneys in the state of Illinois. Of those 65,000, only 170 are subject typically to an investigation in any given year. So we're talking about a very small pool. Just like there's a small pool of bad in anything, there are attorneys that make mistakes, and we're going to talk about some of those. In your opinion, what you know about attorneys, what are some of the common mistakes that attorneys can get in trouble with vis-a-vis their clients?
Well, what I hear a lot, especially from the ARDC, but also from clients who come in who have had an attorney and are not happy with that attorney. The number one thing, I believe, is communication. People don't communicate with their attorneys. They have to be, if you had a case going on, wouldn't you want to know what's going on every single leg of litigation? And that's generally what I do. Everybody knows every time I receive a pleading or a letter, the client gets a copy of it. Every time I receive one or send it, they get a copy of it. My goal is for them to have a file just like mine. Now, there are some differences. If I'm going to send a letter to the clerk to file something, I'm not going to send that. But they'll get a copy of the pleading, no problem there. Discovery, which can be very voluminous, unless it's specifically requested, that's something that I'm not going to necessarily send to the client. Yeah. But that's the number one, I would think, is communication.
So communication or the lack thereof in certain cases can lead to a complaint.
It sure can. I think one of the other ones is simply neglect, which is not taking care of whatever it is you've been hired to do in a timely manner.
Okay, and what would be another one?
I think probably a third one, and we've seen it, although, maybe, we'll see how that goes, would be conversion. Conversion is, taking somebody's money who doesn't belong to you.
Okay, and either not refunding it or just taking it in general when it's not something for the attorney.
That's correct. And you've seen a lot of that. Some of the cases that you look at, the few cases that they've actually pressed, has a great number of those, even though we're dealing with a small percentage, but those numbers are dealing with conversion.
And I think it's important to note that all of those three topics that you mentioned can be avoided very easily. The first one, you talked about communication. That's the number one reason why someone will complain about their counsel.
That's right.
Lack of communication. That can be handled, right?
It sure can. But I think what happens a lot of times is that somebody gets so busy, and really there's so many demands on their time in so many areas, and they're being pushed and pulled apart at so many different seams. And really they need to either kind of lessen the amount of work that they're doing, or they need more help. It comes difficult. But there are also people who send you 20 emails a day and who call you 15 times a day. And I appreciate that whatever is going on is very important to the client because it's their life. That's what's being involved here. But unless it's an emergency, hey, got to explain, look, here, we need to slow down. Because guess what? I'm charging for those phone calls and for those communications and texts and whatever else they're sending.
Right, but some law firms are not on a hourly basis. They're on a flat fee basis. And I know as an associate that works for me or in any firm, if that associate has numerous people to call back and they're not making those calls, the calls are going to continue from the client, and then they're going to pile up on one another to the point where people are going to notice that that associate is not returning the calls. They're probably not returning the emails, and they're probably not doing their work. So it's kind of like a warning sign. If you see an attorney who's not getting back to the clients, that lack of communication is going to lead to further problems, in my opinion.
Well, if it's an associate in your firm especially, because as the principal of your firm, you're the one that's responsible regardless, because you're responsible for supervising the associates under your control.
Right, and everybody's busy. Everybody has a caseload that's probably burdensome, but before you leave for the end of the day, you want to make sure you at least reached out to that person. And young associates too, Jesse, I wanted to point out, they sometimes have a hard time keeping the conversation pithy. They get caught on the phone. They answer a lot of questions. They don't know how to terminate the call.
Yeah, that's a very good point, Dave.
And that takes away work that could be diverted to other people that need a return call, or a letter, or an email, or a fax that needs to go out. So it's the way you manage your time as well would go a long way towards communication.
I agree. I mean, sometimes people just want to get their story out, and if you don't let them get a little bit of it out, they're going to think that you don't care, you're not interested. We both know as attorneys that there are only certain facts that I'm interested in because those are the only facts that are relevant. Those are the only facts that matter. And so, we get to them, and sometimes I'll, we'll turn it around, I guess like they used to do in law school, the Socratic method, and I'll ask questions because those are the areas and those are the things that I need to know. And so I'll say, okay, hey, I appreciate that, I understand, but here, let me ask you these few questions because this is what I really need to know. Right. And then so you could move it along. And then sometimes you get your talkers, as you know, and you have to be a little bit more firm in terminating that call.
Yeah. The other big issue that you mentioned was neglect. I think the way to nip neglect in the bud is just don't take on too much, or if you feel you're getting swamped, get some help.
Yeah.
Or refuse to take that case, or refer them to another attorney who might be more available. I know it's hard to necessarily give up business, but if you're going to risk a complaint or a disservice by not doing the case, you're better off giving up the case or refunding the money and letting him go to an attorney who can actually dedicate the time and skill necessary to make it happen for him.
Sure. Well, even the rules say that attorney's fees have to be reasonable. Part of that is if I've turned down other work in order to take care of your case. So if I'm just looking at your case, Dave, and look, I refused client A and client B and client C because I'm taking care of yours, that factors into the attorney's fees amount, the reasonableness of all that stuff. But when you're also talking about neglect, a lot of times a good calendaring system will help you. It's really difficult to manage. You have at any one time a whole lot of balls in the air, and it's important. You have deadlines, drop deadlines that you need to have and maintain your calendar by things that you have to get done. And so they have to be calendar. I have 3 calendars. One is electronic, one is a breast pocket calendar, and another one is a dupe of that. And so it's very important to have that kind of law firm management. Depends on what the size of your firm is. If you're a sole practitioner, if it's a small firm with 1 to 5, or bigger, and you just go on from there.
Yeah, we're going to get into some of the cases in just a moment, but one last thing on neglect. In my research, I found that the attorneys who were guilty or engaged in conduct which was determined to be neglectful, it wasn't just one case. It was a series of cases. So there was an issue somewhere where the attorney kind of checked out of the practice or didn't want to practice anymore, and whoever was in the pipeline got neglected. So you rarely see it with one individual case, but you see it with many cases in one practice.
Well, usually, if you really look at it, and this is true with your malpractice insurance, the longer you've been practicing, the more chances you stand to have some kind of issues, as opposed to somebody just in that practice. We can speculate. There are a whole bunch of different reasons why somebody could have neglected cases. One is they could have, and again, just speculation, they could have addictions, they could have problems, they could have a divorce of their own going on, all those kinds of things.
Yeah. Let's get into some of these cases now. I want to advise the viewers that these cases have been filed by the ARDC, but they have not been adjudicated as of yet, and we are not going to cast aspersions or assume anybody is guilty. These are just complaints that have been filed. Let's start with a corporation owned and rented condominium units, and they hired an attorney who was going to work for that company, and that attorney was going to be the property manager. And part of that attorney's duties, Jesse, vis-a-vis this property, was to collect the rents from the tenants.
That sounds like an odd thing for an attorney to do.
It is, but he was supposed to collect the rents, deposit it into their specific account maintained at a specific bank. And what happened was the attorney withdrew $29,000 from that account and used those proceeds, this is a problem, to purchase a cashier's check. And then the attorney used the proceeds, allegedly, to fund purchase of his own real estate. So he took what should have been condo funds and used it for his own. At no time did anybody in the corporation authorize that attorney to pull out the $29,000 or authorize him to use those for his own use. So that the administration is saying that the respondent's actions constitute conversion, where you take funds that don't belong to you and you convert them to your own. And by reason of that conduct, the association is saying that the respondent engaged in the following misconduct, specifically engaged in dishonesty, fraud, deceit, or misrepresentation by favoring his own interests above those of the corporation, by using at least $29,000 for his own use, funds that belong to the company. And that's a violation of the rules, Rule 8.4C. So if this is true and if this proves out, attorney has a big problem here, does he not?
It sure does. I mean, you see a lot of that in the political circle. Just turn on the news. You see really conversion of funds, people using funds that they shouldn't be using for their own personal benefit. And in this specific situation, any attorney-client relationship, you have a fiduciary duty. And my goal and my job is, hey, look, is to look out for your best interest, not mine. And it's interesting because it's true, even if somebody was an attorney and if it was, I work for a corporation or you hired me to purchase real estate for you, and I came across this wonderful deal while I was doing that, and I decided, hey, you know what, Dave, I'm going to buy that for myself because it's so, well, that's wrong because I have a fiduciary duty to the corporation. But especially as an attorney, we are held to such a different level and different standard as we should be. There are so many negative things about attorneys. A lot of time, who hasn't been at a party where you've heard these lawyer jokes? And hey, I appreciate it. We can laugh at ourselves, but look, it is an honest, it is a fantastic profession. As you said earlier, there are good and bad in everything. There are good and bad police officers. There are good and bad bankers. There are good and bad
Teachers.
Teachers, exactly, and the same is true with lawyers as well.
Hopefully there's something in mitigation here where maybe a portion of those funds were fees that the attorney was owed or something. I'm not judging in any way, shape, or form. I'm just letting you know that there was a complaint. This is what was alleged. And the way to prevent this from happening is you just cannot touch those funds without authority, written authority to do so. So that's the first case. What do you have, Jesse?
Well, there was another one, and it's just interesting because it was an attorney who has been licensed for maybe 6 years or so, and this person, along with other members of his family, owned an LLC. And so they secured a loan from a lender to run that business. I mean, a really huge loan, like $1.5 million or so. And so as things were going on, they were working with that lender. The lender wanted to have just kind of a lien on one of the parcels of real estate that they own as security. And the way that this works, Dave, is, hey, the lien that gets filed first generally has priority. We talk about liens in different terms of priority payments in bankruptcy, which is different, but generally the first one that's filed takes the priority, just like your mortgage. Your mortgage is filed first. It has a priority over your line of equity. And so that's what happened here. And then they were trying, this attorney was trying to get another loan from a different lender with the intention of paying down some of the first one. The problem is that second lender would only grant them the loan if they were able to be the first in terms of priority on the mortgage, on the property. And so unfortunately, it's alleged that this attorney falsified documents. Now this is just incredible. Falsified a waiver of the priority lien and signed the president of the bank on it for that lender, and also used somebody else's notary to notarize it. It really wasn't that person's, and filed it in the specific county with the clerk's office. And so now we have something that's filed. And then a little while after that, this attorney forged another document, allegedly, and it was a retraction, in other words, a cancellation of that waiver, and did the same kind of thing. And so, and again, all for the purpose of granting that loan. But again, it's falsifying a document to be able to do that.
And if the allegations you mentioned prove to be true,
sure,
this respondent, I think, is in jeopardy with bank fraud as well and wire fraud.
Oh yeah, you can't. Again, you've obviously clearly lied. You forged a document. That's what happens sometimes, is that you see, and there's been at least a couple cases. I just can't remember offhand exactly what they were, but where somebody was dealing, not this really complicated, but dealing with somebody in court and telling them their case was going on fine, would show them, documents that they purportedly filed, which they never filed it. And the thing that I never understood was the effort that it took to make those documents and falsify them and give to the client. You could have just actually filed it.
Yeah.
Could have actually done those kind of things. But getting back to our case, so this guy is accused, of course, the conduct involving dishonesty, fraud, deceit, and misrepresentation, which
Okay.
obviously
Well,
for an attorney is
There's
pretty
a
bad.
lot of things there where the RDC can find fault with, and maybe even the state of Illinois in terms of the bank fraud. Let's go a different direction here.
Sure.
We're going to go to marijuana. Okay, you ready for this?
Yeah, sure.
Okay, the respondent, the attorney, and his girlfriend shared a couple houses in 2 different states. One was in Michigan, one was in Illinois. The attorney had a medical marijuana card under Michigan law, which allowed him to possess 2.5 ounces of marijuana and grow up to 12 plants for medicinal purposes only. Okay? Well, what they wound up doing, the attorney allegedly and his girlfriend, is they grew 24 marijuana plants in one home and over 100 marijuana plants in the other home. So they were basically growers. And it looks like with the intent to distribute. So what happened is once the warrant for the house was issued, the respondent let them exercise it. That's when the police found all kinds of paraphernalia, plants, and marijuana in excess of the dollar amounts. So here we have something that has nothing to do with law. This isn't neglect, this isn't conversion, this isn't miscommunication. This is a criminal matter, and what happened was the respondent, this is the key, he pled guilty to 1 count, which was the conspiracy to manufacture marijuana. The other counts were dropped. But by pleading guilty to that 1 count,
Conspiracy, which is
he engaged in misconduct,
Right.
which was committing a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, and fitness as a lawyer, and that's under Rule 8.4b once again. So here's a lawyer who is in deep trouble, and it has nothing to do with the practice of the law, but it has to do with violating the law. And he had a medical marijuana card. He just was allegedly violating it to manufacture. So what do we do in this case?
Well, Dave, the thing is, again, it's the legal profession, and we have a high standard, as it should be. Okay, when you're going to a lawyer, you're going to trust your life with them, you're going to trust your money with him or her, and hey, that person needs to be honest. Just like you said, there are other cases. Let's say, and I've heard of them where an attorney was caught stealing. Okay, well, that's certainly involving dishonesty. So you have an issue there, and so I guess the thought is you're dishonest with that, right? And so in your profession, and I mean it's a big thing. The ARDC has funds set aside for people who have been taken advantage of by lawyers, and so that's why the attorneys, everybody pays a licensing fee and everything else, and it goes to fund the ARDC as well as those different kinds of things to be able to give restitution back to the people who that the attorney can't make restitution to. And again, it's a shame when you look at these things. Okay, who knows what was going on there? But hey, you spent a long time trying to get your law degree, and now maybe you lost it. Well,
I think the takeaway is if you are convicted or if you plead guilty to specific crimes that have nothing to do with the practice of law or anything regarding the law, you're putting your law license in jeopardy.
Right.
So that's the takeaway there.
Right. There are a lot of different penalties that they can give you. I mean, one, it could be disbarred for a certain period of time. That means you can't practice law. It could be for whatever period of time that they decide. One could be censure, or you could still practice law, but it'll be on your record. Could just be a slap on the hand. They could, depending upon what it is, make you do a class or have somebody supervise you if it's a problem that you had with your accounting or your trust account or something like that. So it doesn't necessarily mean that somebody's going to get disbarred, but for the things that we've talked about, these kinds of things, and maybe especially the other one, there's a very good possibility, again, for whatever duration of time.
Right. What's your next case? What do you have?
Well, and this is a very important one. It involves the unauthorized practice of law, and we'll talk about this case, but then I also would like to talk about bigger issue that we have here with paralegals and other people doing stuff. So this is what we have, is we have an attorney who was licensed in a different state, but never here in Illinois. Comes to Illinois and rents from this particular individual. After a while, this particular individual came to this attorney and said, hey, I'm having problems with a business transaction and a whole bunch of other things that are going on. And the attorney says that, hey, listen, I could represent you on those things. And so initially they just talked about him doing that, but never specifically came to any type of agreement. In the meantime, the attorney, who's not licensed in Illinois, proceeds to correspond with the other attorneys in the other cases, and there's collection cases, and there's corporation cases, and eviction matters, and all that stuff, and is engaged in this and really represented him on that. And then they sit down and they talk, and the attorney and the client figure out a compensation package where one of the things is, hey, he's going to barter a little bit since the attorney rents from this client. Okay, hey, we're going to take some money off of the rent, and he also got paid as well. Well, there came a point, and this is why you really don't want to have business dealings with the client while you're doing different things, because things can turn sour. Apparently, the attorney was late on the rent, and so his landlord, this client, filed a forcible entry and detainer action to try to evict him. So he did that. In the meantime, the attorney filed a bankruptcy for bankruptcy protection, Chapter 13. And so what happens is, Dave, that there's an automatic stay that comes into play. And so the attorney, again, not licensed in this state, files what they call an adversary proceeding, and you could speak a little bit more to that when I'm finished, in the bankruptcy case, basically saying that, hey, this landlord should be prohibited from pursuing his claim for the rent, because everything is included in the bankruptcy, right? And that not only that, but he should also, the attorney should also be compensated for all the work, and the attorney attached times slips and everything that he did. Well, the bankruptcy judge was looking at this, knowing the situation, that the guy isn't an attorney. And so he referred the matter to the ARDC. The ARDC then sent this attorney information, and initially he sent kind of a response. Then they wanted for him to come in to do a sworn statement. He said it and then asked for more time because they had relocated to a different state, and ARDC gave him a couple months, and then he picked a specific date, and then when it came to that date, he told the ARDC that, hey, look, he couldn't make it because of travel expenses and everything else. And so what they pretty much said was, for practicing law in a jurisdiction that he's not licensed, and then for conduct involving dishonesty, fraud, and deceit, conduct prejudicial to the administration of justice in violation of Rule 8.4, which is handling legal matters in connection with the eviction case and all the other stuff. And also, the second count, he knowingly failed to respond to a lawful demand to the ARDC to do that written statement, and then also to conduct which tends to defeat the administration of justice, to bring to the courts or to the legal profession in disrepute. So
does this person have any desire to practice in Illinois
well,
after this investigation?
I don't think that that's probably going to happen again. He's been around for a long time, and as I alluded to earlier, usually it's the attorneys that have been around for a long time that sometimes get in trouble because they're older, they're used to doing things the old way, things are changing, they can't get a handle on all this other stuff, but certainly in this case, it doesn't look too well for this individual. But I want to talk about the unauthorized practice of law.
Yeah, a few minutes that we have left. Let's do that.
Oh, we have paralegals as attorneys that help us get things done, and they draft documents and everything else. Well, the reason that's not the unauthorized practice of law is because our paralegals aren't giving advice to anybody. They're acting under our direct supervision, and we're reviewing their work to make sure, hey, this is copacetic. This is exactly what we're supposed to turn out and what we're supposed to be able to do. Unfortunately, there are some companies that pop up and some other things where they tell people, hey, listen, you come in and we can do your documents and you could save all this time and money and you don't have to worry about anything else. And they do more than just supply the people with the form. They actually help them complete the form. That's where the problem is. They're not an attorney. They're not being supervised by an attorney. And so that's unauthorized practice of law. The reason why the ARDC, and there's a rule against that, is because that's to prevent somebody from just saying, hey, Dave, I'm going to represent you here. Give me $1,200 and I'll take care of your whole case as a flat fee, and I don't know what I'm doing. Lawyers go to school for a long, long time, and boy, you remember the bar exam, Dave? How many days was that? That was over a span of a couple days, because we have to have that unique, specialized training to be able to recognize the issues in the case and to have the knowledge to be able to find out where the law is pertinent to be able to advance and to represent our client adequately.
Yeah, they're also trying to protect the public from miscarriage
Absolutely.
of justice or losing their money or their property or whatnot. But with this attorney here, it seems like he should have known better. He should have known that it was the unauthorized practice of law, and he just didn't. So talk briefly about the rules. We got a couple minutes left. A couple of the rules we talked about, communication, very important, non-commingling of funds. What are some of the trends you're seeing in regard to that?
Well, we have a client's trust account, IOLT account, Illinois Interest on Attorney's Trust account, which any money that doesn't belong to you, and there are different kinds of retainers. I can't get into it here. I don't think we have enough time. There's a traditional retainer, advance payment retainer, security retainer, okay? And again, don't have a lot of time for that, but basically, if it's a security retainer, I'm taking a retainer fee from you, Dave, to secure the work that I'm going to do. I haven't earned it yet. And so what happens is that goes into my trust account because it's not my money. Any interest from that goes to the ARDC, which help funds the things that we talked about in terms of the programs they have for restitution for people who have been injured by attorneys who haven't done what they're supposed to do. And you're supposed to, anything that's not yours, it shouldn't be in that account. However, you can have a little bit of money in there, so sometimes the banks require a certain amount so that the account doesn't get closed. A lot of problems you have to watch out for is if you have money from different clients in that account, and let's just say that I go to pay a filing fee or something from a check I just got from you, right, for the case that I'm filing, and I don't wait for your check to clear, and now all of a sudden your check bounces. I believe that I'd be in violation because now the money that was used to pay the filing fee necessarily came from a different client.
Right, but you have enough in the account as a cushion that you've supplied, correct?
You can't really, only the cushion is really to keep the account open. You can't really have any of your own money. And when you've earned money in your billing, you have to take that out as soon as practicable.
Yeah, certain banks are different on that with how much you have to keep the account valid. Correct?
Yeah, that is absolutely correct. And so, when you have your trust account, you have to be very, very careful. There are also other things. Actually, there's a new rule that you have to, if there's an overdraft, the bank notifies the ARDC and they come knocking.
Okay, thank you, Jesse.
All right,
great
Dave.
information,
You
great
bet.
advice.
Thank you.
We'll see you next time on Legal Action. Take care.